All right, the next bill we have on the agenda, we noticed it for a hearing only just so we could go through it. It's a little bit longer bill. House Bill 194. And we are working off of a substitute LC 480416S. And I'll turn it back over to you.
Thank you, Mr. Chairman. And for the members of committee who might have reviewed this bill prior to today and were working off a different substitute, just to note that there wasn't a bait and switch. It was procedural changes that Department of Community Supervision asked for because the House went into each different crime to input the provision. But it is a long bill. It is most of it is the use of formatting within each section. So there are about 5 major points. If it's at the pleasure of the committee, I'll quickly run over them. The page 2, where section 2 starts, that is the use of lifetime probation. It shows that in the example of aggravated assault. That is paralleled and continues until about line 8, where the sexual offenses are listed. So if you look at the first one, you can see what it's done for each element of each crime, which is after the second adjudicated felony level sexual crime, that the lifetime probation then is triggered. That is a safeguard we put in place. It originally started with one felony level sexual offense, but to scope it in to really try to target the dangerous sexual predators. We know through SORB leveling that the highest likelihood of being a level 3 offender classification is at about 92% of those reoccurring offenders are going to be then leveled. And we don't know that at the time of that first court hearing, but so that is the likelihood. So that's why we utilize those 14 frameworks. Again, that list is on page 8 of the full items. Though it's lifetime probation to set a state standard, there is on page 19 the provision that the state must go before the judge after 10 years of probation. As long as that offender has met all the conditions of probation, the judge is then able to take off that lifetime offense if appropriate. This is really because of State v. Williams instituting that Georgia sheriffs could no longer do a GPS monitoring for a sex offender as a condition of them on the registry. This is the state showing some restraint, knowing that we don't have the most valuable SORB information possible, which comes on while the offender is in custody and in probation, to know if they truly are a level 3 dangerous sexual predator. So we're holding that back and waiting until year 10 of probation to then allow the judicial discretion of if this is appropriate or not. Most of the other items, like on starting on page 14, there's an investigator that switches from GBI to SORB. You'll notice throughout the bill that SORB had requested their name be changed from the Sexual Offender Registration Review Board to the Sexual Offender Risk Review Board. And that is about every major highlight of the bill. I apologize. There is one where you see the GBI did request a change to on page lines 22 to 25 in terms of prosecuting for sexual exploitation of children, how we define having a picture, not the same copy of a picture, but different pictures. Those would be separate crimes charged under this code section. That's all, Mr. Chairman.
So a big purpose of you having the sexual felonies and the mandatory life sentence is a big part of that the ability to still monitor these individuals for the rest of their lives. Is that your main purpose of that?
It's to rectify the public policy issue. We through State v. Williams, about 400 offenders, and that's a general number, went from being monitored where a sheriff had decided after their probation that they still posed a risk to the public. So they decided to utilize what we know is a very strong deterrent mechanism, which is the GPS tool, and have them on there because that's a violation of a Fourth Amendment right. If that individual is not serving a sentence, the court deemed that inappropriate. We can't do anything to those individuals to what some would say rectify the situation if they are a risk to the public. However, going forward, because we know this change in landscape, this would have the state show restraint for a very narrow portion of that population that would, in the future be included in a decision like that, to hold back on not utilizing that tool and give that lifetime probation, which in reality is a 10-year stepping stone to review if that's an appropriate utilization. If SORB, and it can go both ways. SORB finds the most valuable data of risk or non-risk the first 10 years. So there's plenty of instances where SORB's original level 1, 2, or 3 is moved down because of the offender doing classes and just following the law. So by instituting that 10-year period and giving the discretion at that point, it's very likely that an offender that doesn't show a risk has an increased chance of getting off that probation at that time.
And why is this something that we're saying a judge shall do versus letting the judge have discretion to do this in certain cases? Upon
the original second sentence, the policy feeling there is to create a state standard. Again, we are not capturing all the individuals that would be on, that a sheriff would have decided that they're at risk. So we are trying to use a very data-driven approach of why this offender could impose a future risk, which again, 92% of offenders that SORB has in their database now, those that, if we look at those that have 2 of these crimes listed here, they're about 92% likely of being a dangerous sexual predator. So for those instances, we want the state to know anywhere they're at that this is a minimum standard that we're utilizing. And again, holding back the judicial discretion to where the judge has the information that's necessary to determine that true risk.
All right. Any questions for the author, Senator Kirkpatrick?
Yeah. I just want to understand the timing. So currently, the judge wouldn't have the SORB recommendation necessarily, the leveling information when imposing the sentence, right?
Currently, they're likely to not have it, but most importantly, they're not going to have a lot of the valuable information that SORB obtains throughout the time of that offender being in custody to give a more leveling with more fidelity for that offender, both at a reduced risk or at an increased risk to the public based on their behavior.
Any other questions for the author? All right, thank you. There's 2 other people signed up to speak on this bill. First, we have Jill Travis with Georgia Association of Criminal Defense Lawyers. Good afternoon.
Good afternoon again, members of the committee. My name is Jill Travis. I'm the Executive Director and Policy Advocate for the Georgia Association of Criminal Defense Lawyers. We have a few very simple requests. I'm going to shout out some line numbers: 45, 47, 63, 65, 85, 87, 96, 98, 106, 108, 115, 118, 128, 130, 139, 141, 153, 154, 163, 165, 173, 175, 218, and 220. If you look at all those lines, you'll see the word shall. The proper word should be may. In fact, Senator Kirkpatrick probably knows why. She probably could recite verbatim. The Senate has already considered this issue. In 2019, the Senate had a study committee on the protections from sexual predators. It was Senate Resolution 371, championed mostly by Greg Kirk, who was a member of your committee. Reading the final conclusions, the study committee recommends legislative action to give judges discretion to include lifetime GPS ankle monitoring in a sexual offender's actual sentence by having the leveling information from the SORB available at the time of sentencing. The other senators that served on the committee were John Elbers, Randy Robertson, and it was chaired by Renee Unterman. The study committee met in the fall of 2019 and heard from the Prosecuting Attorney's Council, the GBI, the Department of Corrections, the Department of Community Supervision, the Sexual Offender Risk Registration Review Board, and GACTL members. Unfortunately, House Bill 194 does not reflect the recommendation of the Senate Study Committee in any respect, but it removes the judge's original discretion to decide if in this case, this person that stands before this judge should receive a life sentence and should have lifetime monitoring. And it fails to account for the evaluative process that SORB is uniquely able to provide. What will a life sentence mean? It will mean the person is not eligible for parole consideration until he serves 30 years, and he'll have to wear an ankle monitor for the rest of his life. I realize that there is a provision in here that he may come off early, but this bill, I say it's like using an airplane crop duster rather than one of those little hand-turned things that when you put out fertilizer. It spreads this whole life sentence on all of these people without knowing why. Let's talk about some of the crimes. Statutory rape. It is not unheard of a 19-year-old to be dating a 15-year-old. That's a high school senior and a freshman. Enticing a child for indecent purposes can be accomplished via a sting operation with a law enforcement officer posing as a participant when there's no actual touching involved. Improper sexual conduct. That could be a 22-year-old substitute teacher being romantically involved with a 17-year-old student who's not actually the student in their classroom. Computer pornography. It's when a person uses a computer with identifying child information for the purpose of offering sexual conduct with a child. It's a viewing crime, not a doing crime. This bill removes all the discretion. It just looks at the name of the crime. It doesn't look at the person or their actions. The Senate knows better than that. This bill expands the number of people who will receive life sentences and increases the length of Department of Community Supervision, which will increase the DCS caseload and will require more resources. That was something that was brought to the attention of the study committee. So there's a fairly easy fix. I know I gave those line numbers out pretty quickly, and I can obviously provide that information to you. I want to also bring to your attention something that was added kind of last minute. So you understand the purpose of this bill. The purpose of the bill is to deal with the Parks decision, which was that somebody did not receive a life sentence and therefore could not be monitored for life because of constitutional concerns. This bill was not about changing the law on how to prosecute child pornography cases. On lines 222 to 225, that was a last minute change that was added in the House committee. It doesn't account for the fact that child pornography and downloading of images, I think Brendan Spar is testifying after me, and he has a better sense of technology than I do. But I do know that, sometimes you click on something and then you get more than you thought you were going to get. Well, this would allow prosecution for all that you got, even though you weren't intending to get all of it. And that's a problem. The language in this, the way it's written, we think is problematic, and it doesn't go to the spirit of this bill. I'm happy to stand for any questions.
Any questions for Ms. Travis? Thank you very much. We have one other person signed up to speak. Brendan Spar, Executive Director of Restore Georgia. Good afternoon.
Good afternoon. Thank you, Mr. Chairman and members of the committee, for allowing me to speak to you today about House Bill 194. My name is Brendan Spar. I serve as the Executive Director for Restore Georgia, which is a nonprofit organization made up of all volunteers who are a collective voice for people impacted by sexual offense laws in Georgia. Mr. Chairman, last week in the House Judiciary Committee, you remarked about how thorough that committee was, and you wanted to bring that back to this committee for the equal thoroughness. So in doing your diligence
I was
on this
being
bill...
sarcastic, of course, right?
Well, no. You were thorough, and this committee is thorough. So in being thorough, consider the reason this exists, as Ms. Travis said. It's to protect Georgia from sexually dangerous predators. That's the root of this bill here. The Sexual Offender Registration Review Board classifies the dangerous predators by looking at several factors, none of which are the crime that was actually committed. They're looking at things like the age when they were committed the crime and the victim, the age of the victim, some other things like that. They're not looking at the actual letter of the crime. But what this bill would do is it lists about 13 different crimes, and it considers those crimes. So the sexually dangerous predators, as Representative Saines has mentioned, make up some of the smallest group that SORB levels. It's 3% of everybody on the registry. This bill would give the judge two options when sentencing someone for those 13 crimes. Life in prison, that's on the table under this bill. Life in prison is on the table. But also, if the judge feels that that's excessive, they can give life probation after a mandatory 1 year of prison with the ankle monitoring. So life in prison could be eligible for some of these cases. There are already 200,000 people on probation in Georgia. This would add an additional 7% to the Department of Community Supervision's caseload without giving them any additional funds. And speaking of money, electronic monitoring fees amount to about $1,000 per year. And the last minute change that DCS asked for was that those fees not be incurred by DCS as they are today, they're incurred by the person on probation. So somebody with this level of crime, let's face it, is not going to get the best job. They're going to be struggling to make it. Now they're on the hook for over $1,000 a year. If they don't pay it, they're revoked. Their probation's revoked for the duration of the term, which is life. They're going to prison for the rest of their life for not paying their monitoring fee. Not to mention, they could be violated if they are out of cell service, if they're up in the mountains, if they go swimming and the monitor malfunctions. They could be revocated for that, which is life. So as we learned in the 90s, a war on crime is not effective. Back then, we're issuing life sentences after 3 strikes. This bill would go further and issue it after 2. Changing shall to may would allow a judge to fully evaluate the circumstances, including the risk classification. By the time someone commits a second offense, they could have a risk classification. So let's let the judge be a judge and see that, get all the information, and if they feel that it's warranted for this person to spend the rest of their life in prison or on probation, so be it. I urge you to change shall to may and give judges a say.
All right, thank you very much.
Thank you.
That's all we had time to speak on this bill, and that'll conclude this hearing. We're adjourned.